HFFX LLP and another. I'm the Commissioners for His Majesty's Revenue and Customs.
Good morning, Mr. Yates.
Good morning. So I'm going to be making submissions on the sales of occupation income question,
Yes.
and that breaks down into 3 issues.
Lovely.
Condition A, main purpose, which we've managed to call Condition B wrongly in our skeleton, and Condition B. I'm going to address those in that order. I've spoken to Mr. Chaco, and we've agreed to divide up the time according to this. I'm going to get 1 hour and 15 because I'm going to have to introduce the legislation and of scene setting. He's going to have an hour, and then I'm going to have a 15-minute reply if required.
Thank you.
So HFFX, or rather the individual appellants, were unsuccessful on all 3 issues before the UT on this. But the appellants obviously only need to be successful on one of them in order to succeed on this appeal, assuming you're with Mr. Prosser in relation to the 687 issue. Now, none of these issues were addressed by the Court of Appeal in Bluecrest because it dismissed the appeal on the 687 point. There's simply a comment, I don't need to take you to it now, at paragraph 127, and that is Authorities Binder 5, tab 38, bundle page 1184, where I might as well read it out. Sir Lancelot Henderson says, in my view, it would be unwise for us to embark upon an examination of ground 2, that is the sale of occupation income issue, in circumstances where its resolution is not necessary to the disposal of the appeal. Anything we said on the subject would inevitably be obiter. Although we heard full argument on it, I am satisfied that at least some of the issues to which it gives rise are far from straightforward. They are better left for determination in a case where their resolution matters to the outcome. So here we are. Just by way of background, it's not in the bundle, but this legislation was first introduced in the Finance Act of 1969, Section 31. And it's going to be my submission that obviously at that time, still is the case now, but at that time the distinction between a trade on the one hand and a professional on the vocation was quite distinct. They obviously had separate cases back then, so trade was Schedule D, Case 1, professional vocation was Schedule D, Case 2. Nowadays they're all charged under the same charging provision under Section 5, Vitoria. But there remain some, not major, but some differences in terms of the tax treatment of a trade on the one hand and professional vocation on the other. And it's my overall submission that when the draftsman, whether you look at this current legislation or its predecessors, was well aware of the distinction between the two. So if I may, if we can turn to the authorities bundle and to the first folder of it, I'd like to take up the legislation. And if we turn up page 34, so turning to tab 4, page 34, you should have in front of you section 773. And this is really it's both an introductory section, because it's sort of laying out the landscape, but it also contains a substantive condition. So subsection 1, this chapter imposes a charge to tax where individuals are treated as having income arising to them under either 778 or 779, but sub 2, income is treated as arising under those sections only if transactions are effected or arrangements made to exploit the earning capacity of an individual in an occupation. That gets defined in much more detail a bit later on. But then B, the main object, or one of the main objects of the transactions or arrangements, is the avoidance or reduction of liability to income tax. So that's the only, that's where the main purpose provision is. It's not separately defined or addressed anywhere else in the chapter. If we then turn over the page, we then come to section 774, and this defines what is the meaning of occupation. This essentially feeds into, as we'll come on to see, section 777. But 774 provides that references to an occupation in relation to an individual are references to any activities of a kind undertaken in a professional vocation, regardless of whether the individual is A, carrying on the professional vocation on their own account, so they're self-employed, or B, is an employee or office holder. And I'll come on to make submissions about that, but the legislation is obviously, when one normally looks at tax legislation and one sees professional vocation, one normally sees it in the company of the word trade. Here, the omission of trade, in my respectful submission, is deliberate. And what I'm going to be coming on to develop in my submissions is when one is having to apply this question of whether the individual appellants were carrying on activities of a kind in their occupation, the proper approach is, if one concludes that what they're actually doing is activities of a kind typically undertaken in a trade, one stops there. One doesn't then go on to apply what may well be quite wide definitions of profession, and certainly on the revenues case, vocation, and say, well, you're caught anyway. If we then move on, I don't need to look at 775, but if we can go on to 776, this is the actual charging provision. And the only point I just would like to note there, well, first of all, the person's charged is the individual to whom the income is treated as arising. I suppose no surprises there. But one will see that this is subject to an exception set out in section 784, and I'm going to come on to address that. That's subsection 4. And then we come on to the main provision, which I imagine we're spending most of our time on, section 777. That's bundle page 38. We're told that sections 778 and 779 only apply if conditions A to C are met in respect of an individual. Condition A, the individual carries on an occupation wholly or partly in the United Kingdom. Condition B, the transactions are effected or arrangements made to exploit the individual's earning capacity in the occupation by putting another person, that's defined at 782, in a position to enjoy all or part of the income or receipts derived from the individual's activities in the occupation, or indeed anything derived directly and indirectly from such income or receipts. That's then expanded upon in sub 4. We're told that references to income or receipts derived from the individual's activities include payments for the description of for any description of copyright, license, or franchise, or other right, deriving its value from the individual's activities. And the draftsman goes out of his way to say past activities as well is included in that. And then condition C is that as part of or in connection with or in consequence of the transactions, a capital amount is obtained by the individual for the individual or another person. That's not in dispute. And the way this fits in to the 687 point is 687 comes first because what one has to look at under sub 7 is a capital amount has to be an amount in money or money's worth. No dispute about that. But it cannot fall to be included in the calculation of income for the purposes of the Income Tax Acts otherwise than as a result of this chapter. So the priority is 687 first and then 777. Moving on, we then have 778 and 779, these two alternative conditions which essentially at the core of the charge. 778 is on page 40 of the bundle. And the difference between the two is essentially this. 778, the capital amount has to consist of property which does not derive substantially the whole of its value from the individual's activities, or a right which does so. And then if one moves on to 779, the capital amount mentioned in 777 consists of property which derives substantially the whole of its value from the activities of the individual. Now, I don't think the revenue have ever clarified in this case which provision they were relying on.
I asked a similar question
Yes.
in Bluecrest.
Well, in the FTT, we said we assume you're relying on 779. I don't think the revenue ever answered that question. It's not set out in any of the assessments or anything like that. I believe in Bluecrest, the revenue plumped for 778. I'm not taking a point about any of this, but it'll be interesting to see which one Mr.
You think that was the answer to my question? I got an answer and I can't remember what it was.
Well, I believe the answer was, and I believe Mr. Chacko was actually making the submissions on this point, is that it's all to do with whether 779 is a prospective. It's talking about whether it's deriving their values prospectively from, i.e. from future activities.
But anyway, you think the HMRC went for 778 in Bluecrest?
I understand that they
Yeah.
did. Mr. Chaka is going to correct me if I'm wrong about that. Yep. No, he's nodding. So I think the revenues. I think I can take it safe to assume that 778 is what you're relying on here as well. Yep, indeed. So 778 is what they say. So the property. So that in this case, that's the special capital. Does not derive substantially the whole of its value from the individual's activities. And I understand from the argument in Bluecrest is that by the time it is special capital, it obviously has derived in one sense on the revenues case from the individual's activities, but its value isn't going to fluctuate anymore by reference to them. I think that's essentially the revenues point.
So the point being that in both Bluecrest and this case, investments have been acquired.
Yes.
Is that the point?
Well,
Or is
it's
it
just
something-
cash because if you recall,
No, but the values have fluctuated with the value of the investments. Is that the point?
they would have
Is that
had
the point?
in the intermediary period. So if you recall, GSAM invests
Yes.
its profit allocation in investments.
Yes.
It then realises those and
Indeed.
recontributes. So, and I think we differ slightly from Bluecrest in respect of this. It recontributes it as special capital,
No, I realise
not
that.
far before it's reallocated.
But I'm asking a much more simple question.
okay.
Why is it that the property doesn't derive substantial? Anyway, maybe Mr. Chaka.
I think that's a point for
can
Mr.
answer it,
Chaka. What I would
but
point out,
I'm still a little unclear.
well, it's process whispered, cash doesn't derive its value from anything. But it is interesting if you go back and look at 777, and that provision in 777 sub 4, it said that one can derive value from past activities. That's a minor headache for Mr. Jacko. I don't think it ultimately much matters because it's no part of my case that Mr. Jacko is going to be shut out because he hasn't plumped for the wrong section.
I see.
But deriving can obviously mean two things in tax legislation. It can either mean, as a tracing exercise, can you trace it all the way back to some sort of activity carried on by an individual? Or does its present value, does it represent the value of, and this I think is what Mr. Chaka's point is, but, activities which are currently going on? Maybe the draftsman, in the space of two sections, hasn't applied that consistently, maybe, or maybe they have. But I believe it was an issue which troubled you in Bluecrest, and I'm not sure there is a satisfactory answer to that question. But I don't think it matters too much for
No,
this.
okay.
This appeal. If we then move on to 782, so this is bundle page 45. This defines who is the other person. And for relevant purposes here, if you look at sub 2, a partnership or partners in a partnership may be regarded as a person or persons distinct from the individuals or other persons who are for the time being partners. So that would do two things in this case. It would deem HFFX itself, the LLP, to be another person, as well as deeming GSAM to be another person. And the revenues case is obviously focused on GSAM. The retention partner. But that's going to be relevant for when we come on to it, condition B. And then finally, if we go to 784, we can see, if you recall at 776, that subsection 4 of 776 referred to this provision, and it exempts certain transactions from the charge. And if one looks at 784 sub 1b, you can see that there is, the section applies if there's a disposal of a share in a partnership, which again is carrying on a professional vocation. So note again there, trade is not mentioned there. Why? Well, the draftsman presumably assumes it's not necessary. And A, yes. The draftsman assumes it's not necessary to provide an exemption where the activity being carried on is a trade. So those are really the relevant sections that we have to consider here. In terms of the submissions then, I'd like to first deal with condition A. And there are two, the best place to start I think is the FTT decision, which is in the core bundle. So that's core bundle file 1, tab 16. And the relevant discussion for sale of occupation income starts at paragraph 209, and that's at page 248 of the bundle. And if you have that, 209 and 210 set out the relevant excerpts from two cases. One is Burt, one is Maxi. I don't really have to go into the underlying facts of that. What I'm really relying on those cases for is essentially a distinguishing between, or defining what a profession is. And particularly if one looks at Maxi in 210, we see a profession involves the idea of an occupation requiring either purely intellectual skill or, if any, manual skill, as in painting or sculpture or surgery, skill controlled by the intellectual skill of the operator. And then this is important, as distinguished from an occupation which is substantially the production or sale or arrangements for, and I would underline arrangements for, production or sale of commodities. And it's obviously, the appellant's case here is they fell within that latter category. What did they do? Well, they all had various different skill sets, but ultimately, what were the activities of the individual appellants? They worked together in order to build and then operate and ultimately alter, if necessary, an automated trading system which bought and sold either currencies or FX instruments. So that commodity is essentially in the language of Maxi. The starting point is obviously that HFFX, and it's never been in dispute that HFFX was itself carrying on a trade. That's never been disputed by the revenue. So when one first starts to approach Section 774, you start with the following background. The activities which the individual members carry on as members of the LLP, they are treated as carrying on the activities of the LLP as a whole. So as a matter of conventional income tax treatment, they are treated as carrying on the trade of the LLP as if they were a partnership.
So that is undisputed.
It's never been disputed before. It's certainly been mentioned or accepted as a trade in the revenue statement of case below and in various skeleton arguments. I don't understand Mr. Jagger disputes it now, but I'm sure he can interrupt if he wants to.
He looks troubled, but I think we'll hear in due course.
We'll hear in due course.
He does look troubled.
He will say it doesn't matter because for the reasons I'm going to come on to, and this is ultimately what the FTT did. So when one looks back at 774, the appellants are carrying on a profession. They're not carrying on a professional vocation on their own account. They're carrying on a trade. Nor are they employees or office holders. But on the revenues case, that's not the end of the inquiry. It's because one has to focus, if one goes back to the authorities bundle and focuses on the words of 774, are they of a kind carried on in a professional vocation? So, and the revenues argument is that notwithstanding that they are, as a whole, carrying on a trade and partnership, their activities, when looked at, I suppose, in isolation, are of a kind undertaken in a professional vocation. And that certainly was accepted by the FTT. And we say that, in any event, the FTT erred in approaching the question of what the individuals did on an isolated basis. And in order to build that submission, because I accept that this is an Edwards and Bairstow challenge, I'd like to take you to the witness statements, which describe the nature of the activities which are set out in the supplemental bundle. The first witness statement is that of Mr. Gerko, and that's in Supplementary Bundle File 1, tab 13. And if we can first turn to page 86 of that bundle. all of these witness statements essentially cover three separate things. They start the story with some, but not all, of the individual appellants being employees of GSA. Then there is essentially an outsourcing of their activities into HFFX LLP. And then, because HFFX LLP is so successful, we see that they then, from 2014 onwards, so 2010 is when the LLP is created, late 2010. By 2014, they're just parting ways with GSA entirely and running their own business completely separate from GSA. And during the period of time which we're looking at with HFFX, the arrangement was that members of HFFX were seconded to GSA in return for HFFX itself being a member of the GSA partnership. And then what happened was ultimately 50% of the trading profits from the GSA partnership, GSACP, I think it's referred to.
Well, it's the trading profits attributable to this activity.
Sorry, quite right. So 50% of the trading profits attributable to this high-frequency FX trade is then apportioned to HFFX, and then those profits are then apportioned within the HFFX partnership itself. In reality, and we can see this, what happened is they sat along other trading teams, but they were a self-contained team within GSA at the time. And that's one of the features which I'll have to comment on, which is, they didn't have their own infrastructure. For example, they were within a GSA building, but obviously what they had actually done in terms of the really valuable infrastructure, which isn't just the computer terminal, they essentially had to build all their trading software from scratch. So if we come on to look at Mr. Gerko, paragraph 12, again, this is talking about when he was employed by GSA Capital Limited. But what I'm relying on this for is just a brief description of the activities, which they do change over time, but not in a way that I think is meaningful for this inquiry. So if you can see there at paragraph 12, those systems traded high volumes and needed to respond to market conditions as fast as possible to take account of opportunities, referred to as low latency. And once they began operating, such strategies require constant refinement to ensure that they remain competitive while new strategies are continuously developed and launched. So what's happening here is that the HFFX team is obviously had to build the trading system first, and then it's having to continually update it in light of trading conditions, and presumably someone else has got another algorithm going at another trading house, and you're essentially competing with them and the rest of the market in order to remain competitive.
But these, as he says in paragraph 12, are a team of researchers and developers.
Yes.
Who research and develop initially and then use their expertise to constantly refine.
I am not going to try and get away from the fact that all of the members of HFFX were highly qualified individuals. Many of them were PhDs in maths.
I'm sure.
It was not possible to trade in this market with maybe an old-fashioned computer terminal and gut instinct. That world had just gone. It's certainly gone now, and it had even gone back in the days of 2010. So that was the relevant trading environment if you wanted to compete in this sphere. If we then move on to paragraph 17, this is the background for the negotiations, but again, essentially, GSA convinced Mr. Gerko with his team to stay, and they said, well, they're essentially trying to shop for his business. Slightly peculiar environment where the employee has got so much leverage over their employer that the employer is then essentially saying, well, we want to keep you. We can essentially service your trading needs better than somebody else. And in particular for Mr. Gerko, it was crucial that he kept the intellectual property in relation to the trading strategies. Then if we move on, 19, this again describes how things started. At this point, they were employees of GSA, about how to get the trading operations up and running. And as he comments, as it turned out, the infrastructure at GSA was very poor, and we effectively started from nothing as far as computer systems were concerned. Extremely busy time, but within 4 months we had developed our initial trading strategies and built the required software to begin trading. And then, again, moving on, at 26.3, this is now describing the situation. If you look at 25, it's under the headline Formation of HFFX. So this is the proposal from the middle of 2010 to set up as a separate LLP. And the team was going to, if you look at 26.3, the team was going to be seconded and would carry on the same types of high-frequency trading activities for the GSA funds, but in return, HFFX was going to become a member of GSA CP and get 50% of the trader payout. So that's the deal as I described it. And then 35, again, just continuous narrative there. Once we became members of HFFX, we were seconded to GSA and continued to perform the same high-frequency trading activities for the funds, but this time as members of HFFX rather than as employees. Now, that's not true of all of the individual appellants. Some of them only joined HFFX afterwards, so not all of them were ex-employees. If we then move on to Mr. Howson, he is behind tab 14, and the first bit I'd like to go to is page 109. I just invite, this is just a broad level description of how automated trading systems work. If I can just ask you to read paragraph 5. And then if we move on to paragraphs just 10 to 12, that's at pages 110 to 111 of the bundle. And just really the last bit of 10, so he's describing his role, which is responsible for programming the automated trading engine. And the intention was the team would engage in proprietary trading on behalf of the GSA's funds. So GSA is putting its own money. GSA is not sort of booking trades on behalf of its own clients. It's putting its own money at stake.
Well, I think GSA is a fund manager. So
it is, absolutely.
The funds
yes.
It manages at stake.
Indeed. And again, no dispute. If we look at Mr. Howson, his role was to take mathematical models, you see this at paragraph 11, and algorithms designed by others within the team and write computer programs that implemented them to form a fully autonomous trading system. It was described a bit more fully in the evidence that the statisticians and mathematicians could write pretty good code, but in order to make it ultra fast, you needed to sharpen it up essentially in order to gain the advantage in the market. So that was the mathematicians we hear could do some coding themselves, but it wasn't up to trading standard essentially. And that was Mr. Howson's job. And then at paragraph 12, there's a description of what essentially GSA, the deal was with GSA. So from the start, the team operated mostly separately from the other trading desks in GSA. We shared the same back office functions such as HR and compliance. GSA provided some ancillary software, office space and computer equipment. But the core software development and research teams were managed autonomously. We had our own unique procedures. Risk limits for our trading were agreed and set with GSA management. And as far as I recall, all major decisions needed their approval. So essentially what happened was this team of individuals set up their automated trading system. GSA put in various things such as trading limits and maybe a kill switch if it got out of control. But the idea that exactly, maybe just pulling the plug, but the idea that someone else at GSA was receiving this computer development services and saying, thank you very much, I'm now going to carry on doing the trading, that's complete fantasy. what ultimately happened was, this was the trading team. Yes, legally speaking, GSA was the entity which entered into those trades, but there was no sort of active engagement by GSA in the conduct of these individual trades. That was obviously done, individual trades were done at high speed under an automated system. The oversight and management and continual tweaking of that system was done by HFFX members. And then lastly, if we just go to Mr. Baretza, his witness statement is at tab 15. And again, if we could just turn up paragraph 11. So that is on page 128. And this essentially is quite a good oversight in terms of the dividing line between the two, broadly, the two groups of individuals who worked as part of HFFX. So I'll just invite you to read paragraphs 11 and 12. So you can see that distinction which I've alluded to is the models produced by the researchers, sort of academic style models, coding, whatever, was then turned into code which was going to be sufficient to carry out high frequency trades. That's essentially what the computer developers did. And then if we move on to paragraph 15, there's a brief description of the GSA systems. So essentially the team, whilst they were still at GSA, I would hasten to add, had to essentially rebuild all of the GSA trading systems essentially from scratch. And then 19, there's a description of how HFFX operated as a separate business. You can see that at 129. I invite you just to read that. So where I want to go with my submissions is, in the FTT, well, I'm going to go and take you to what they've said. The FTT accepted this distinction in my submission between professional vocation on the one hand, trade on the other, but found that it made a positive finding that the activities of the individuals were not activities undertaken in the course of arranging for the buying and selling of commodities, for example. We challenged that conclusion. That's paragraph 73 of our skeleton. What the Upper Tribunal did was to say, well, don't accept any of those criticisms of the FTT. And what is more, the Upper Tribunal said, is we ourselves would have found that this would have answered the question of profession, you know, as a broad term in accordance with its ordinary English meaning. See Burton Cousins, I think, is what it said. We say that is also wrong because, and that is an error of law in a sense, because what it has done is just simply ask the question, can I possibly describe this as activities undertaken in the course of profession, without asking itself the prior question, actually is this trading activity? So there's the errors which we complain of essentially are slightly distinct depending on which level of appeal you're looking at. Obviously, this is an appeal from the Upper Tribunal. The FTT, our complaint about the FTT decision obviously feeds through into...
So you say the effect of section 774 is that if it is a trading activity, these provisions do not apply. Is that what you're saying?
If you conclude that these activities are of a kind which are distinct from being a profession because they are activities for the arranging for buying and selling commodities, broadly speaking, that's our case. Yeah, as per Maxi, that distinction. you can't go on to conclude that these are therefore the activities which of a kind undertaken in a profession. And indeed, the revenues case proves too much, as we're going to come on and see.
Well, yes, the revenue effectively broadly say there can be an overlap.
Revenue says, well, they don't just say there is an overlap. I think the logical conclusion of their submission, particularly on vocation, I'm not accepting their submission on vocation is correct, but they say a vocation can be any systematic way of making money.
Yeah.
Well, that by definition includes every form of trading activity.
Okay, but focusing on profession versus trade,
Yes.
the revenue say there can be an overlap. Just look at whether it's the kind of thing carried on in a profession. It doesn't matter that there is in fact a trade going on. I think you're saying that's the wrong approach. Well, I'm not quite sure how far you're going with that.
Maxi says, let's go back to the express in the FTT. So that's core bundle, tab 16, page 248.
Yeah, we've got your point about buying and selling. Is that your focus? Or I thought you were making a different point about statutory interpretation of 774.
Well, it is my case on statutory interpretation that the draftsman has deliberately left out trade.
Yeah.
And therefore, you have to respect that distinction. So what you can't do is say, I agree that these are activities of a kind undertaken in the course of a trade, and then say, notwithstanding that, I can still, and this is ultimately the ambition of the revenues case, I can still get them because profession is so wide, and certainly on the revenues case, vocation is essentially every possible activity imaginable, that you're still going to be caught.
Because it dissolves the distinction.
And the revenue say, well, we can do that because this is an anti-avoidance provision. So we can go as wide as we want. And the Upper Tribunal had some sympathy with that submission. But in my respectful submission, anti-avoidance provision or not, if the draftsman has made a deliberate choice to say, okay, trading activity is not included within these provisions, what one can't do is say, oh, well, it's anti-avoidance, we can essentially just ignore that guardrail and say we can capture that activity as well.
We are saying that 774 recognises
Yes.
that distinction.
Indeed. And as Mr. Provost says, Maxi, the distinction which is in Maxi is recognised in 774 in the way that occupation is actually defined. And indeed, if one comes on to that other point at 784, the draftsman again gives you this let out if your partnership is carrying on a professional vocation. There is no exemption if your partnership is carrying on a trade. Which again, that would be bizarre.
Yeah.
If you're going to be caught. So yes, you can take a wide view with an anti-avoidance provision. I've got no truck with generally taking an expansive view on anti-avoidance,
No,
but you still have to
you've answered
respect.
my question. I think you are making a point about the correct interpretation of 774. The revenue focus on the of a kind, but there are some specific subparagraphs in 774A and B. I think you're relying
Indeed.
on them together with 784.
And that was an error in my submission, the Upper Tribunal. In my submission, I think the FTT respected that distinction. It's just that we disagree with how it went about them making findings of fact in relation to that. The one thing the FTT did say, and maybe I need to take you to this now, if you look at 215, you can see the same submission being made. Just invite you to read 215. This is on bundle page 249.
No, so that's accepting the wider version that the revenue.
That's a slightly different point. What the FTT is saying there and rejecting a submission from the appellants is, I understand it was common ground, maybe Mr. Jacker says it's not, but HFFX is carrying on a trade. Mm-hmm. What you can't say is, simply because of that fact, that HFFX is carrying on a trade, anything done, including the in-house accountant or the in-house lawyer, even though they are carrying on something which, let's say, is unambiguously the activity of a profession of a kind, carried on in a profession, they can't sort of say, well, this can't apply to me because it's sort of, I'm being bolted onto a wider trading activity. So that's what I understand the FTT to be rejecting there. what the FTT then goes on to do, or sorry, has done earlier, is actually ask the question, are these activities arranged? So you look at this at 212, where they reject a separate argument. I do not accept the appellant's argument that their activities amounted to making arrangements for, or the exercise of commercial knowledge in, the buying and selling of commodities. That's earlier on. So that I am very much challenging that.
So what do you say about 215?
215, I don't think, it depends how you interpret it, but we are not saying that simply because HFFX is carrying on a trade, we win. You have to look at the activities of the individuals. That's essentially, that's the approach that was advanced in the Upper Tribunal. I think Mr. Prosser accepted the FTT was correct when it said that at 215. But when you are looking at the activities of the individuals, you still have to respect this distinction between trade on the one hand, and profession and vocation on the other. Now, maybe, my lady, you think that you know, the FTT was wrong when it said that at 215, but that's certainly the way the case is advanced. So if we look up the page, because this is really the entirety of the findings the FTT has actually made, I would just invite you to read paragraphs 211 to 213. Yeah, I know. And those are the passages which we essentially challenge at paragraph 73 of our skeleton argument. And what we say essentially is, if one is, the legislation doesn't care whether you are self-employed or an employee. Simply looking at your activities, it's not asking whether, by definition, an employee is not carrying on a trade, or indeed, you know, they're not carrying on a profession, arguably. And that's an issue we see with the definition of company in 784. If you recall, when you look at 784, it talks about whether a partnership is carrying on a professional vocation. It just says sale of a company. Now, why is that? Well, it appears to be implicit in the revenues, or the drafter's view of that a company can't carry on a professional vocation. And that was a question which was ultimately put to bed in the CTA 2009 rewrite. There's a very long discussion in the explanatory notes, they're on the bundle, don't plan to take you to them. But essentially there's a very long and detailed analysis of the law as to whether a company can carry on a profession, because it's all about depending upon your personal qualifications, and a company itself has no personal qualifications. And equally, a company can't have a calling to do anything in its life, or can't pass its life in a particular way. So there might be, and I can't put it any higher than that, a presumption in 784 that a company can't carry on a professional vocation, which is why it's silent on that when one looks at 784. But that's an aside. When one looks at the test in 774, one doesn't ask the question, are you carrying out this activity on your own behalf or on behalf of somebody else as an employee, because both are potentially caught. And therefore, much of the FTT's points which they make are, well, you're not buying and selling, it's GSA. or it's not your infrastructure, it's GSA's, etc., etc. That's completely irrelevant, because the question is, what is actually the nature of your activities as a matter of substance? The reality is that it was the HFFX team. No other human being was involved in the buying and selling of these FX instruments. Yes, there were controls placed by GSA, and yes, the legal entity which entered into those trades was GSA. No disputes about that.
You're saying effectively it was through the agency of these individuals.
Exactly. And yes, they individually had skills such as being statistics, PhD, or a computer developer. But when one's looking at their activities, you don't just look at them in isolation. You're looking at what they're actually doing in reality, which is working together as part of a team, actually as a part of a partnership. And the only thing they're doing, as a matter of substance, is building and monitoring a high-speed trading program. That is trading par excellence. The fact that they themselves don't individually enter into trades doesn't matter. Nor does it matter that it's not their computer, the physical computer in the room is not something they own. That is not something which, in my respectful submission, 774 cares about. Because if that's true, then why does it say it doesn't matter whether you're carrying on it on your own account or whether you're an employee? So what the draftsman of 774 is really focusing upon is the substance of the activities of a kind. And that's why it doesn't really matter whether you're self-employed or an employee. That's my overall submission. In any event, simply when we come on to look at what the FTT has actually said here, so if we take it sort of line by line, there's the overall conclusion at 212. It's clear from the evidence that the individual members that their activities in respect of HFFX were the design and development of software trading strategies. Well, that's true in one sense, absolutely, but it wasn't as if they were designing a computer system and then going around and selling it to, or providing computer consultancy services to a variety of customers. They were doing this simply to buy and sell currencies, in which they then partook of 50% of the profits. Yes, they were using someone else's funds. So what? That's not really getting at what the substance of their activity was. And again, why the FTT says their titles, whilst not conclusive, support this. The team consisted of researchers and developers, not commodity traders or market advisors. Well, in my respectful submission, the title which they have is simply not relevant at all. They also are referred to, we sit on a trading desk, we get trader payout. I don't think whatever label you put on these individuals' activities ultimately matters. I'm not disputing for a moment the skill sets of the individuals involved. But the question is not simply, are you a highly skilled individual? The question is, in what context and what are you applying that skill set to? And the question here was, they weren't providing statistical consultancy services. They were using their statistics and computer programming skills to trade in high-frequency currency markets. That's ultimately what they were doing. Maybe it's time for a facetious example. Let's assume that the new Labour government...
Maybe not.
Mr. Yates, is this wise?
Decides, as part of boosting the GDP of Britain, that we need to remove the rules on Champerty maintenance. And so a vibrant market in buying and selling legal cases ensues. Let's assume that, God forbid, you three all decide to tire of the bench and decide you're going to apply your undoubted legal skills in this brave new world of buying and selling cases. You are undoubtedly highly skilled individuals. You obviously were practicing lawyers before then. In some senses, you could be regarded as a professional. But what are you actually using that skill set for? You're not doing it to provide legal services or to provide legal advice. You're doing it to buy and sell commodities and to profit from the difference. And that is ultimately I've used that example to obviously bring home, we're all lawyers here, we think of ourselves as inherently professionals. But simply because you use legal skills, regardless of context, does not mean you are a professional in every single manner that you use those skills. That's the point I'm making. And so what the FTT has, one can understand why it's sort of gone for the easy things such as a label or whatever. It said, well, you're a computer programmer, that's a professional. You're a statistician, that's a professional. Without actually looking at what is the activity to which you're directing that skill set to. And the activity to which they're directing that skill set to is obviously buying and selling currencies.
And perhaps you're also saying, although you may be not, Mr. Yates, that in this day and age, that trade in itself is actually conducted by the means of algorithms, etc. And so it isn't that you are providing something which is going to be used at the next stage.
Indeed.
It is the very nature of the trade.
Indeed. And that's where it does become curious. So I've already made the point about infrastructure. Well, leaving aside, yes, GSA did provide infrastructure, but a lot of the valuable infrastructure was the software, which they had to build themselves. But then it does look curious if one looks at 213. It says, Mr. Gerko stated that the team's trading strategies were to be available to be used in GSA's funds. That is, any buying and selling that took place was undertaken and arranged by GSA. Well, yes, as a matter of identifying who is the legal person in whose name these trades are carried out. But when one looks at the evidence, there is no undertaking and arranging by GSA, other than it's allowing its computer systems to be accessed via HFFX. And for HFFX's trading program, which obviously the IP was retained by Mr. Gerko, to execute those trades in GSA's name. So, in my respectful submission, something has gone very, very badly wrong with the FTT's reasoning there. The fact that the strategies developed were used by GSA to buy and sell commodities does not affect the nature of the activities of the individual members of HFFX. Well, in my respectful submission, that is too narrow a view. When one's been asked by Section 774, what is the occupation of these individuals? You have to look at what, as a matter of reality, they're doing, rather than just saying, well, you're a computer programmer. That's essentially all you do is code. But the question is, my respectful submission, to what end? You're using your computer programming skills to participate, along with others, within this currency trading market.
It must be more complicated than that. I was just looking back at the quote from Maxi. I mean, there must be a wider range of possibilities than that, because you could, the example given in Maxi is of an occupation as a painter or a sculptor.
Yes.
On your analysis, the moment you had a digital artist who sold his work, he'd be into a trade and he wouldn't be an occupation anymore, and it just can't be that simple.
But a digital artist is...
Or any artist doesn't need to be a digital one, a sculptor or an artist.
Well, no, I think a digital artist is not buying and selling. A digital artist is not an art dealer. So an art dealer is a trader, but a digital artist who sells their own work, that's them selling... Well, that's very different context, in the way that if I decide to write a book, I am actually trying to write a book at the moment.
You won't make a profit.
Let's hope we're not a footnote.
If I'm just selling my own book, I'm not a trader in that book. I'm simply selling the fruits of my own work. I'm currently a professional, so it would probably be part of my profession. But a sculptor could be a professional or a vocation. That's very different from buying and selling currencies or potatoes or rice or whatever. That is a fundamental distinction, respectfully, which the tax legislation recognises. And then again, it goes on to say, the fact that the income of HFFX was calculated by reference to the profits earned by GSA from the strategies developed by HFFX does not mean that the members of HFFX can be regarded as buying and selling. Well, yes, I would accept that. Simply because you profit from it doesn't mean that you're treated as carrying on that activity. But my point is a wider one, which is it doesn't actually matter whether you're buying or selling. What are you actually doing? Are you making arrangements for the buying and selling? And that's very old parlance, which we see in Maxi. But undoubtedly that encapsulates a situation where you build, implement, and continually update a model which engages in trading activity. So I think that captures all the points I want to make. The overarching point is that the legislation should not be interpreted as extending to activities of a kind undertaken in a trade. That's obviously deliberate. A professional vocation is clearly distinct from a trade, and the limit must clearly be a policy choice of the drafter. And what the UT does, and we can just go on to that very briefly, so that's core bundle tab 11, and I'd like to go to 173 of the bundle. You can see its conclusions there. I mean, essentially, it tries to characterize these as all complaints about weight to give to a factual this or that. That is not our case. It's simply that the FTT applied the wrong approach. Obviously, understood the distinction correctly. It set out the test in Maxi, beginning of the discussion. But then its characterization of the activities of the individual members was an error of law. And as I've alluded to briefly at paragraph 112, simply to say, well, the word profession is an ordinary English word, if it's possible to construe what they've done as professional activity, that's the beginning and end of the inquiry. In my respectful submission, that ignores the statutory context in which that word is used. I've already made that submission. So I think that's all I want to say about condition A. I then move on to the case of the question of main purpose. And again, if we can just go back to the FTT decision. And the FTT decision starts at page 253 of the bundle. And essentially the fundamental complaint which the individual appellants make is there are certainly findings by the FTT that tax was important. Not disputing that at all. There are certainly findings that the Mr. Gerko in particular, who's correctly identified as the key decision maker, knew about. The difference between proceeding with the cap and going along with a default situation where profits were allocated, but let's say kept on a restricted basis and possibly forfeited later. The issue why that was found to be objectionable was, let's say you, under a partnership model, you have 100% of the profits allocated to you of your piece of the pie. 50% of that is held back and is potentially forfeitable. But obviously under 850, you're allocated 100% of that profit. Now at the time, obviously only for a brief period, the tax rate was 50%. Then went back down again. But the objection was, I'm going to be taxed on 100% of my actual profit allocation, i.e. the bit that isn't deferred. And what's more, the bit that is deferred is potentially forfeitable, but I won't get any correction to my profits to reflect that fact. So there clearly was a choice made by Mr. Gerko and, well, in particular Mr. Gerko, but the other members who signed up to HFFX. Now the question is, that choice, our submission is that choice of itself does not permit the inference that there is a main object of avoiding income tax. And passage from Brebner is set out in the skeleton. Clearly, Lord Opchan says there, if you've got two options available to you, simply selecting the one with the lower amount of tax does not necessarily, and I accept it's all about necessarily rather than you're automatically off the hook, doesn't necessarily mean that it's that you have a main purpose of avoiding tax. Now, what the FTT did, if we just go down through its findings, it's very clear that and again, don't challenge this finding at all, very clear that the the idea of the cap came from GSA. GSA, from the evidence, appears to have implemented a similar provision for its own members. But this was a cap being imposed upon HFFX, not because GSA was interested in saving the members of HFFX tax, but rather as a control mechanism, as we've seen from the evidence, to essentially control HFFX's behaviour. And we've seen, obviously, when HFFX tried to set up a new business, XTX, the GSA's ability to control the cap was an important dynamic, not a necessarily welcome one, but it was certainly part of GSA's approach to control the members of HFFX using this cap. And if we look through the findings in relation to Mr. Gerko's objects, we can see, can we just start at 230? There's basically a finding there that he knew there was a significant tax advantage could be expected with the cap. No issue with that. Para 231, the benefits must have been important, and again, we don't challenge that. And 232, there's recording there that Mr. Gerko didn't take any tax advice, but nor is there any evidence that he took commercial advice about it at all. That's not strictly true in the sense that this HFFX agreement was commercially negotiated, as Mr. Prosser said yesterday. There's no finding either way on that. And at 235, there's then a discussion about GSA's objects, 235 to 240. And the FTT accepts that the HFFX arrangements did not reduce GSA's tax liability, but GSA intended to use the same arrangements. Again, no quibble with that. But then when one comes to the reasoning at 241, it says, I consider it clear from AG's evidence that he had a main object of reducing tax and agreeing to the cap, as he considered that the alternative restricted fund share arrangements carried an unfair tax position, and also believed that there would be tax savings to the use of the cap. Now, in our submission, that is not enough to find that there's a main object. In circumstances where revenue not disputing that the function of the partnership as a whole certainly had a commercial purpose, the cap wasn't originated from HFFX's members. It was, as it were, thrust upon them by GSA. And what the FTT has not really engaged with is the idea that if this is really a tax-driven arrangement, it's obviously not being suggested or imposed by Mr. Gerko himself, it's being imposed by a third party. Yes, maybe you can take into account their motives, but if their motives are not to try and save HFFX members income tax, quite except GSA might have had a tax motive in relation to its own arrangement, that again can't be relevant to determine whether there's a main object here. And what there is ultimately is an absence of reasoning. There's a recording of evidence, none of which we object to. But that evidence on its own does not support the finding, which the FTT made very briefly, that there was a main object to avoid tax and thus satisfying the condition which we've seen in section 773. So it's a very narrow point. It's simply, there's a recanting of the evidence. We're not challenging those findings themselves, but what we say is they just don't lead to a finding where you can conclude that there is a main object. In this sense, we're very different from Bluecrest. Appreciate Bluecrest, they conceded the question about main object. But in Bluecrest, obviously they developed their own equivalent to the cap. Here, the context is important. Namely, the cap is imposed upon HFFX as part of the deal to roll them out into an LLP so that another party can ultimately use that cap to control. And the only question is, the only thing the FTT ultimately alights upon in terms of its reasoning is, well, you knew that there was an advantage. Well, anyone who's commercially advised is going to know about that. Ultimately, Mr. Gerko didn't get tax advice. He was informed of that by GSA. You found the alternative unpalatable, i.e. an effective 100% tax rate, at least up front, until you got your money at a later date, in terms of the vesting, for example, under the restricted fund share option. That in of itself is just not enough, we would say, as a matter of law, to conclude that there is a main object. But that is what the FTT has done here. So just in light of the time, I think that's all I want to say about main object. If I may, can I just then go on to condition B? Condition B is not dealt with in substance by the UT because before the UT in this case, it was accepted that it was going to be very difficult to persuade the UT in this case to depart from what the UT said in Bluecrest. But if we just turn back to the language of section 7.7, so back to the authorities. So page 38. Condition B is that transactions are affected and arrangements made to exploit the individual's earning capacity in the occupation by putting another person in a position to enjoy all or part of the income or receipts derived from the individual's activities in the occupation. And ultimately, there are the following difficulties with this in the context of a partnership. First of all, the reference to an individual's earning capacity is not apt to cover a collective activity in a partnership unless it is to the individual's right to share in those profits. And as we see, the legislation certainly does envisage, this is a point made by Mr. Jacob and Skeleton, that if you sell your share in a partnership, you are going to be potentially, not automatically, but potentially within this legislation. The second point is, putting another person in a position to enjoy does not apply to the allocation of profits within a partnership, as opposed to, for example, the transfer of a share. So it cannot be said in this case that GSAM enjoyed income or profits derived from any particular individual's activities. The legislation does not. The legislation certainly does envisage the sale of a partnership share potentially being caught, but that's because a partnership share obviously is the income which you will get from your activities as part of a collective within a partnership. What this legislation doesn't do is say that because of the manner you've decided to allocate profits within a partnership, so that in this case GSAM gets an allocation of profits. What it doesn't do is bite on that, because it can't be said that GSAM in this case is in a position to enjoy the income, i.e. the profits, derived from, let's say, Mr. Howson's activities.
A person's individual profit share in a partnership could give rise to income or receipts derived from their earning capacity.
Certainly in relation to their share, yes.
In relation to their share?
Yeah, absolutely, yeah.
Even though that itself derives from a collective activity?
Yes, but I think I have to accept that, because otherwise what on earth is 784 doing?
Yes.
Obviously, there's two potential other persons here. What the revenue have not said is that HFFX is the other person here. So you have to start off from the starting point that everyone is a member of this partnership, including GSAM. The revenue are not saying HFFX has got the receipts. We're going to come on and see a brief passage from OD. HFFX is not the other person on the revenues case, it's GSAM. And so, obviously, the trade as a whole of HF is being carried on by HFFX itself. This is a point the FTT makes in OD. And all that GSAM has is its rights as a member. It is not as if income at any stage for the years we're looking at arises, there's income which can be said to arise from an individual's activities, which is then sort of transferred over or has been assigned over to another person. That's not our fact pattern. What we're starting here with the establishment of a partnership. Revenue take no point about HFFX being the other person. They're simply focusing, and one can understand why, because they then have to say the entire partnership has got a main object of tax avoidance, which even a bridge too far for the revenue's expansive argument. So they're not arguing that HFFX is the other person. They're saying the GSAM is. But then the question is, well, GSAM is a member of this LLP. Has it got Is it in a position to enjoy income derived from the individual's activities? No. It has got a right to enjoy its proportion of the profits of the trade carried on by HFFX. And if I may, can I just take you to the relevant passage in OD? Appreciate I'm running up against time here. But if one goes to OD, that's in the bundle, Authorities Bundle 4, tab 35, and if we just turn up page 1012, you can see there a discussion, paragraph 398, condition B, and the arguments are set out. So Mr. Chacko for the revenue, Mr. Goldberg for OD. You can see Mr. Goldberg's argument. No other person is put in a position to enjoy any relevant income of the members. In fact, OD, so that's the LLP, was the person with the income and receipts from the fund management business, and it put the individual members in a position to enjoy part of that income by allocating it to them. No member taken on his own has income or receipts which another person can enjoy. In other words, there is nothing equating to the sale of occupation income in this case. And you can see if we then move on to the conclusions at paragraph 400, that's on page 1013. I just invite you to read paragraph 400, and then I'll just make some very brief submissions on that. So just for context, as you're reading it through, OD is the analog for HFFX. PCSL is the analog for GSAM. And then, I'm not going to bother going through the facts, but when it talks about individual shares awarded, the approximate analog for that is the pre-retention amount. Or the amounts allocated to GSAM. And then we can see how those arguments are then dealt with by the Upper Tribunal in Bluecrest. So same bundle, Authorities Bundle 5, tab 37. And I'd just like to turn up page 1127 of that bundle, if I may.
Can you give me the page number again?
1127.
1127.
So the discussion starts there, and then the conclusion is at 135 and 136. So 135 is essentially some fact-sensitive points made in relation to the findings in Bluecrest, which don't carry over here. I entirely accept Mr. Pross's characterization that this was a deferral arrangement in terms of the cap. But that doesn't, the fact that GSAM was, had profits allocated to it by reference to a pre-retention amount doesn't alter the fact that what one is talking about here is a collective nature of a partnership and its profits. So one can appreciate the presentational points being made here by the Upper Tribunal. The earning capacity of a member of a partnership is their partnership right, and this does not include profits allocated to GSAM. They were never entitled to profits which ultimately were allocated to GSAM, nor were they entitled without more, unless allocated to them, the profits flowing from HFFX's trade. They never gave their partnership share to anyone else. And merely because GSAM is a member of a partnership does not mean that it is enjoying any individual appellant's earning capacity. And then at 136, what the Upper Tribunal focuses upon is Section 782. We would submit here that the fact that a partnership can be another person is neither here nor there. It doesn't explain what happens within a partnership. So obviously here, it's not the revenues case that the other person, when one is looking at Section 777, is HFFX. They're saying it's GSAM. What the Upper Tribunal's reasoning here does not address are questions of where the earning capacity is within a partnership and where the question, what the revenue are trying to attack ultimately is the allocation of profits within that partnership. So I think that's all I can say. I think it's now from, I think, Mr. Chacko, and then I have a 15-minute right of reply or whatever I'm going to get shaved off.
I'm very grateful. Thank you. Mr. Chacko.
Thank you, Maria. So I was going to deal with the tax avoidance purpose first, then profession vocation, and then condition B. So the question of a main purpose of tax avoidance is obviously a question of fact and assessment. And the approach to a challenge to that is in the authorities at Doe, which is volume 4, tab 36. And I'd like to take you to page 1070. And the passage is paragraphs 35 and 37. And I draw your attention to the quotation from Fage and Chibani that this applies not only to findings of primary fact but also to evaluation and inferences, and to the frequently cited passage from Giorgio and Marios Chippery as to what you need to do to make good such a challenge, which includes identifying the relevant evidence to the finding and showing that it was impossible to make the finding on the basis of that evidence. If I could now take you back to the first tier's decision on this issue. This doesn't start at page 253, it's the original taken to, I think. It starts at page 250 because the passage should be read as a whole from paragraph 223 to 247. You're probably familiar with that already, but so unless you want time to read it, I'll just direct you to the bits.
Just press on.
In particular, I'd point you to paragraph 231 in the assessment of Mr. Howson's evidence. And paragraphs 234 to 240, where they weigh up what GSA's purposes were in designing this, based on documents which you have not been taken to and which are not in the bundle. In particular, the HFFX proposal and the correspondence between GSA and Mr. Gerko on that proposal. And I would say from that that the appellants simply have not properly made a factual challenge to this. They haven't attempted to take you to relevant evidence. On this point, I think they haven't actually taken you to any evidence at all. Nor have they shown any error of law or principle. What they have done, as the Upper Tribunal observed, is selectively quote the reasoning to suggest that a test was being applied that was not in fact being applied. There was a much more general weighing of the material in those 25 paragraphs I identified, than simply saying Mr. Gerko knew that there was going to be a tax benefit and that he preferred not to pay 100% tax up front. There's a lot more material there, a lot more material to consider, and this, I would say, is hopeless as a challenge to a factual assessment. The Upper Tribunal deals with this at 114 to 128, and I endorse what they say there, but I won't take you to it now. Moving on to professional vocation. The finding, of course, was profession. Or strictly, it was activities of a kind carried out in a profession. But you've been taken to the witness statements extensively. They're not much of the case law itself, and I will have to take you to some of the case law. But I would say that unless you're satisfied that the first tier approached this in the wrong way, you shouldn't really be reading the witness statements at all. This does involve factual assessments. Therefore, the principles I've taken to you in Doe apply here as well. And the appellants haven't made properly an Edwards and Bairstow challenge to these assessments. What they have done is taken you through a selection of the evidence to re-argue their point, which they argued at first instance, that this was in substance trading. They argued that and it was rejected. Just as an example of the sort of trouble that you can get into by doing this, they, as they did in the Upper Tribunal, have said that the first tier shouldn't have paid much attention to who owned and paid for the infrastructure, and it's been suggested that doesn't matter very much compared to the software itself. I mean, in fact, the computing, the hardware and the power and for this kind of thing is extraordinarily expensive. And that's the kind of thing which could be ventilated at first instance, but is simply unsuitable to be dealt with on the second level of appeal. Finally, before I move on to the actual legal test here, it's been said that it's common that we've always said that the partnership was trading. And the answer to that we have said, we've always been said, we've said from the beginning, that it is in a sense trading, because trading has wide and narrow meanings. We frequently referred to trade because Section 850, which was the other part of this case until we were bound by Bluecrest, refers to trade, though that itself it defines in Section 847 as trade includes profession or vocation. But we said, and we said this on Day 3, with the transcript, which is at page 228 of the supplementary bundle.
So is that FTT?
FTT transcript. 228 of the supplementary bundle. Day 3, page 77, lines 12 to 16. I said, well, I'll be referring to trade consistently. That's just because trade is used in a wide sense rather than a narrow sense. So, in the context of 850, so we said you cannot place much weight on the fact that we have generally referred to the partnership's trade when dealing with the division of the profits of the
sorry, could you give me the internal page and line again?
The internal page of the transcript,
Yes.
day 3,
Yep.
page 77, lines 13 to 16.
Thank you.
So, going on to the law. Section 774, which is at page 35 of the Authorities Bundle, Volume 1. Reference to an occupation are reference to any activities of a kind, and I've struck both any and of a kind, undertaken in a professional vocation, regardless of whether the individual is carrying on a professional vocation on their own account or is an employer or office holder.
Do you say that A and B aren't an exclusive list?
They aren't an exclusive list of...
Well, because if you say these individuals are partners in, let's just say for the sake of argument, a trading partnership. The of a kind language is not repeated in A, and they're not employees or office holders. That's why I was asking whether a point of statutory interpretation was being made here.
I say that what that regardless is doing is making clear that you are not supposed to worry too much about exactly how in the actual world these individuals make money, because they may be making money through some other activity, through some other body. And I say you read that together with of a kind, so you look at the kind of thing that they are doing and whether that's the sort of thing that you do in a professional vocation. But you're not supposed to worry too much about the structure for which they do it. And the reason you're not supposed to worry about that is the whole of this code exists to deal with a situation where they don't earn money through their professional vocation because they set up a structure so somebody else does. So you're not supposed to be able to look at it and say, well, actually, in fact, they're not carrying on a profession. A structure's been set up so the money is made in a different way, because that's entirely what these
Okay,
reasons
so
are
I
targeting.
think the answer to my question is you aren't reading A and B as exclusive.
No, I don't
You're
think so.
basically saying, regardless of the particular mechanics.
Yes, I see them as
essentially.
regardless of the particular mechanics. And I'd say that these aren't defined words. The Upper Tribunal was right to refer to Brutus and Governs, that these are words of ordinary English meaning. And while there is old authority both on what profession means and what vocation means, they are just guides to how we use those words. They are not setting up a legal test. And that for the appellants to win, they were able to show that there was an overlaying legal test, not implicit in these words. And the test that they, I think, need to show is that you have to first say they are not involved in a trade. And once you've found that, you're allowed to ask whether they're carrying on activities of a kind in a professional vocation. And that phrase, that restriction is certainly not there on the face of the section. There's nothing that says you've first got to decide that there's no trade. And it's true that generally speaking, we do divide activities into trade, profession, and vocation. Not universally. I mean, in some of the old cases, they use different sets. Partridge and Maladine, the legal test there was profession, employment, or vocation. That was clearly not really supposed to be disjunctive because you can clearly be an employed doctor. And the cases like Maxi dealing with excess profits duty, the legal test is trade or business, and they carve profession out from that. So historically, trade has been used in a varying way. I don't dispute that generally now, when you decide someone is carrying on a trade, you're deciding that individual is not carrying on a profession. It doesn't mean that there are actually very clear, hard-line distinctions. And you'd get that, for example, from Carr in the Court of Appeal, where on the facts they held that an optician was carrying on a profession. The High Court turned around and said, no, he's selling spectacles. And the Court of Appeal said, no, you should have stood by the initial finding. We're not finding in general whether opticians are professionals. We're saying whether this individual is. And you could have found it differently, but you didn't. So it's not, you don't set up divide the world into clear professions, clear vocations, clear trades. There'll be some cases which are very obviously on one side of the line or the other. You won't start saying that a doctor in private practice is carrying on a trade. You won't start saying somebody who is selling vegetables at a stall is carrying on a profession. But there are hard cases, and it doesn't mean that there isn't a real distinction to be drawn. And in this case, the tribunal decided that they were software designers, essentially. And that is what they were. They're very, very expensive software designers. I mean, the point's been made that they share in the profits of GSA, which is fund manager. But I would say that an architect who gets a cut of the profits of the builder doesn't stop being an architect. And that was the assessment the first year took. They decided that the best way to characterise this was that these were people who developed software. And for what it's worth, the definition of the business in the LLP deed is to second people to GSA. I'll just give you the reference for that. That's on page 13 of the bundle. And next, we're at the point that the language here is wide. Occupation is the term being defined, and that's a wide statement. And then they use the phrase "of a kind," which itself expands what you're looking at. And you can be guided by the purpose of this provision, which I would say is targeting activities depending on personal skill and characteristics, because those are the sort of activities where you could, in a sense, forward sell your work for capital sums. And it wasn't targeted at people who make things and sell them, or buy and sell at a higher price, because they cannot really alienate their future earnings in that way. And this explains why what the draftsman was thinking about was people that they would think of as professionals or as involved in a vocation, but they wouldn't typically think of the core example of trade. As we put in the skeleton, one of the reasons might be being established by the time of this legislation that someone who sold commodities, if they transferred their stock in trade elsewhere, that would be taxed as a trading receipt. That's Sharkey and Werner. Whereas Mason and Innes had held that you couldn't say that with an author or a professional more generally. You didn't, when they transferred a book that would produce itself for future earnings, and I think he gave it to his father, you didn't work out how much that was worth and then put that in as a profit of his trade that year. But so people who buy and sell things aren't expected to be able to do this, as in exchange their future earnings for some kind of capital But that's, I'd say, why they didn't say trade. It wasn't that they were implicitly setting up a legal test that you have to satisfy before you get into the factual inquiry. Are these of a kind? Let's take you to the old authorities, which I say the tribunal applied correctly. We've got Max C, which is at Bundle 1, Tab 8. And there are the comments of Lord Justice Scrutton on page 95 of the bundle, which we line. And I'd say he's commenting on what he thinks the word means. He's not setting down a legal test. I think this is, or if he were setting down a legal test, it's not one that's found in the other decisions. But I don't think he's ever really been treated as setting down a formal test. What he's doing is explaining what we tend to think of as a profession, but also making clear that it develops. There are people that you would historically not have called professions that you would now say are in professions. And similarly, when you get to the comments in Burt, if you read the head note of Burt, which is at 98, what I point out to you from the head note is that the passage from Scrutton on the last page, page 117, where he says, whatever may be the limitation of a profession, I do not think it applies to the exercise of commercial knowledge in connection with the sale of goods. That's not part of what, well, all three concur, that's not part of the ratio of why the case is rejected. The other two don't say that. As a general set of observations, we don't disagree with what he says there. Generally speaking, it won't be. But bear in mind, this actually is a case which is about kind of international trade and the sale of goods produced in the Far East. He's not laying down a general rule that once.
Sorry, you're referring to his reference to I do not think this applies.
Yes.
It applies to the exercise of commercial knowledge.
Yes. So he is actually looking at a case which is very much core to what people would think of as being merchants, as buying and selling things. And I don't think that's setting down a general rule that if you can describe something in that way, even in as unfamiliar way as you'd look at the case here, you then automatically stop being a professional. Carr, I've referred you to for the discussion, for for the fact it was treated as a factual question which could go either way in that case, whether the opposition should be described as a professional or not. That passage in Carr is at page 190, internal page 165 for E to H. And then if you go to depart on the next page, you'll see at D to E, he makes even clearer that he feels this could be decided either way. And then the remainder of that, from it seems to me dangerous to try to define the word profession, where I rely on that passage to the end of the judgment for the comments as to how it's a developing idea at different times and different circumstances. Different people could be validly described as in a profession. New professions have grown up and more may grow up in future. And this all supports the view that, as the Upper Tribunal thought, this is a Brutus and Cousins question. This is an ordinary, the profession is an ordinary word, it doesn't have a technical meaning. And so, is it fair to describe, is it not just is it fair, is it reasonable to describe software designers of this kind as doing something of a kind that might be done in a profession? And I'd say very clearly yes. That's also supported by Bluecrest in the Upper Tribunal, paragraphs 132 and 133. So I'd say there's clear Court of Appeal authority in Carr, it's a question of fact, not of law, that the boundaries of it have changed over time, and that applying dicta from 1919 to a modern financial services regime, let alone computer, sort of software-based financial services, is of limited use. The FTT's decision at 209-212, which you've been taken to, draws on the guidance from the old case law, considers intellectual skill and sale of commodities, and rejects the taxpayer case. Similarly, you've been taken to the Upper Tribunal at 110 to 111, and I say they were completely correct to say this was a challenge to wait, in the sense that these are all arguments that could have been and were made at first instance, but the first tier judge didn't agree with them. I think it's also notable that the Upper Tribunal, also a specialist tribunal, at 113 said that they would themselves have said this was of a kind in a profession. I was going to ask Mr. Kirby, my junior, to speak briefly on vocation, and then I'll go on to condition B.
Thank you. Mr. Kirby.
Ladies, this is the issue addressed in our respondent's notice. The reference is core tab 4, page 68. My submission is that a vocation is an organised way of making money that is not buying and selling things. It's a simple submission. And the support for that is in the case law, starting with the case of Partridge and Mallandine, which is the authorities bundle, tab 5, page 53, and if I could take you there. Starts at page 53, but if I could ask you to read the lined passage on page 54, which is the judgment of Mr. Justice Denman, down to the end of where it's lined.
Well, that's an unusual way of thinking about a calling, I think. Never mind.
So yes, one can have a calling to be a bookmaker at a race course.
So it seems.
So held the divisional court, and as they say, it's a word of wide signification, meaning the way in which a man passes his life. So it is a very wide word on the case law. Then turning to Graham Greene, which is at tab 11 of the authorities bundle. Page 127 is where it starts. Decision of Mr. Justice Rowlatt. Here, this is a similar case to, in that it's about betting, but this was a man who, instead of being a racecourse bookie, he just regularly made bets and was quite shrewd at doing so and turned a profit on it. And he didn't have a vocation. But if I could ask you to read the lined passage, starting towards the bottom of 130 and going over
130?
yes, down to
Thank you.
the end of the line passage on 132. So what I take from that is that organising an effort, so organising a way of making money, is a vocation, generally speaking. The exception to that is if you're organising your way of making money by buying and selling things, then you have a trade. That's what Mr. Justice Rowlatt is saying there. So it's a wide word, but the core case of buying and selling things in a trade does fall outside it. And taking those two cases on the meaning of vocation, Parliament can be assumed to have had those cases in mind when it was legislating the sale of occupation income legislation. And this meaning also accords with the modern meaning of the word. If one thinks of vocational qualifications, for example, it's a wide word that extends to any organised way of making money. So, do the activities here fall within that? Do they fall outside the definition of profession for whatever reason? My submission is they do. They're clearly an organised way of making money. I'm sure that's not disputed. And there's no buying and selling things going on here. firstly, the FTT found that they weren't buying and selling things, as Mr. Chappie referred to, paragraphs 212 to 213 of its judgment. And following from what he said as well, they were secondees providing services to GSA.
Which, sorry, FTT 13.
Sorry, 212 to 213 is
Yeah.
the full passage. So for those reasons, we say that this is, if it's not a profession, a vocation. Those are my submissions.
Thank you.
Mr. Chappie.
Thank you, my ladies. It's so condition B, which is set out in the legislation 777, so that's page 38 of the first authorities bundle. So transactions are effected or arrangements made to exploit the individual's earning capacity in the occupation by putting another person in a position to enjoy all or part of the income or receipts derived from the individual's activities in the occupation, or anything derived directly or indirectly from such income or receipts. If you go to the core bundle, page 19, you have the ground of appeal on this, which is that 2 sub 3, the operation of the tax did not put GSAM in a position to enjoy the income derived from individual appellant's activity in any alleged occupation. As we say in our skeleton, we say, this is paragraph 82 in our skeleton, that this is limited to whether or not GSAM enjoyed income derived from the activities, rather than wider questions as to whether or not there is an arrangement to exploit the individual's earning capacity. But I will address you on the whole of the testing condition B, so that you so that you have the revenues position if you deal with it in full. And I think it's worth starting with how we say in this case condition B is satisfied and how it's supposed to work. So I took you yesterday to the LLPD and how 10.3 in that, 10.3D, provided for allocating to GSAM at least 30% of the pre-retention amount or a higher quantity if that for the purposes of incentivization. And as I explained, that is the only substantive provision allowing profit allocations to GSAM. If it already has special capital, it will get the income on that special capital. That's the only other allocation it can have. And the pre-retention amount is defined as the sum that Mr. Gerko would potentially have allocated to each individual member if there hadn't been the Capital Allocation Plan. And the basis on which you'd make those allocations is set out in the tribunal at paragraph 45, this is evidence on it, this is page 216 of the core bundle. Because this is where he's explaining when he tells GSAM, you've seen the letters with percentages set out for each individual. So GSAM will be sent a letter with a list of percentages. I mean, it might be worth just looking at one again. So supplementary bundle. There's one at. There's one at tab 4, if you go to page 67, and then on page 67 of the supplementary bundle. It starts at 66. And this is where recommendations are made for reallocations to be made to individuals. And you'll see there's a list of percentages. So GSAM has been told the total amount it's getting, and then it's being given percentages that are to be reallocated. and that's as provided for in Schedule 6. You'd see at the bottom of page 56 of the bundle, there's a gap. They assume in the LLPD this is what's going to happen. They'll have a series of
Sorry,
names.
page 56 of the supplementary.
Yes.
That's Schedule 6 we were looking at yesterday, yes.
So part of the LLP agreement is this schedule. They are to be sent these letters. There will be names and percentages. And Mr. Gerko's evidence, this is 40 subparagraph 5 in the FTT, that the percentage recommended was based on the cumulative performance of each member and would increase over the first few years of the team. But he points out that as one of them starts to do better, their percentage will go up, and that knocks down other people's percentages. And cumulative in that phrase, he means cumulative of the performance over the last few years of that member, not. It clearly isn't based on the cumulative performance looking across all the members, because he's talking about how he's dividing it up. So half the amount that Mr. Gerko would have allocated to each individual member, but for the cap, goes to GSAM. And I've taken you through the letters showing how that happens. And what we say is that this is actually a much simpler case for Condition B than something like Bluecrest, where it wasn't documented as clearly, because this is all set out within the LLP agreement. You have an amount which becomes the income of GSAM, and that's directly tied to the fact that it's not becoming the income of the individual member. The individual member's profit share is going down, and GSAM's is going up, much more starkly than in Bluecrest. And we'd say that when you then look at Condition B, 10.3D as applied means that there are arrangements made so that this other person, GSAM, has become in a position to enjoy all or part of the income or receipts derived from the individual's activities. The FTT found at 170 that the purpose of the CAP was to defer amounts derived by the individuals from their work. So we'd say that's an express finding, that the sums being deferred, which are what are going into the CAP and then going to GSAM, are derived from their activities.
And that's at 170?
Yes.
Yes.
And that this is exploiting their earning capacity. I mean, earning capacity, this I think is the error in OD. OD approaches this by saying, well, they haven't actually got a right to any of this. In fact, it's somebody else's income, because it's not like they already had their profit share and it was then given away. But the whole point of this code is to deal with a situation where somebody else has earned the money instead of the taxpayer. If it was the taxpayer's income, you wouldn't need this code. It's specifically about the case where it's somebody else's income, but it might have been the taxpayer's, but for this arrangement. And I'd say that the operation of 10.3 makes that extremely clear in this case. So it doesn't matter that Mr. Shakin didn't have a pre-existing entitlement to be awarded 14% of the profit share that then comes through this. It's as clear as it could be from the agreement that the reason that share has gone to GSAM is because it's not going to Mr. Shakin. And so, is that an earning capacity? Earning capacity isn't a defined term. It doesn't appear elsewhere in the legislation. And I'd say it's construed naturally. It's what somebody could have earned It's the income that, but for these arrangements, they could have received. And that, I'd say, is exactly what's happening here. I think the Upper Tribunal was right to bear in mind that this is a widely drafted code dealing with intended to deal with a very wide range of business structures. It was right to bear in mind it's an anti-avoidance code. Its primary limit is the anti-avoidance purpose, but it's not designed with a particular small number of transactions in mind. It's designed with the idea that this kind of professional may be able to alienate income and, as in, avoid getting income, but be rewarded in some other way. But they're not prescribing what other way. Section 774, as came up in questioning earlier, I say is indicating that the structure isn't supposed to matter. In terms of whether there's any problem using this within a partnership, I'd say that can be shown not to be a problem by 784. 784 is dealing with sales as a going concern. And so if a partner sells their share in a professional partnership, the sale falls outside these rules, the value of the share is attributable to the value of the profession as a going concern. That's 7841B and 4. But if that value itself is derived by, it flows from prospective, as in future income from continuing activities, then 7851 brings them back in. Unless, this is 7853, they're actually going to be paid full consideration for those continuing activities. So if you sell your partnership share, but that includes your future work, so you get a capital sum, not just the current value of your third of the partnership, but on the basis that they know you'll still be working there and the value's been elevated, that will be caught by this unless that elevation in value is still being taxed as income. But what I say is important about this for here is that 784 and 5 assume throughout that you can attribute both earnings and income to the activities of a particular individual partner. These sections don't work if you can't do that. And so Parliament hasn't said that OL partners all actually earn money in common, and so there's no such thing as an individual partner's earning capacity, there's no such thing as income derived from the activities of an individual partner. 784 and 5 assume that you can talk about individual partners in that way. And in terms of the means in which the potential earnings of, say, Mr. Shakin become earnings of GSAM, or income and receipts, I mean, these words are all used. I'd point you to 780, which is page 42, which is account is to be taken of any method, however indirect, by which any property or right is transferred or transmitted, or the value of any property or right is enhanced or diminished.
I've lost that. We're on 780.
780 subsection 1.
Thank you.
And here, precisely what 10.3D does, in combination with the definition of pre-retention amount, is diminish the right to share in the profits of, for example, Mr. Gerko or Mr. Shakin, and increase the right to share in the profits of GSAM. This is all on the basis that the taxpayers have won on 850, and therefore these allocations genuinely are the rights to share in the profits. And so I'd say this is quite a clear example of condition B working properly. This is exactly what it's after. The point of this deferral arrangement is partly that their income in this year is reduced, and they get it back in a capital form later. So that is exactly what the sale of occupational income provisions are targeted at. So those are my submissions on that part of the case. So unless you have any further questions.
Thank you very much indeed. So, Mr. Yates.
Thank you. So I'll just deal with my reply in the same order as that which Mr. Chaco's used. So firstly on tax avoidance. So there Mr. Chaco complains that I haven't gone through all the evidence, haven't got through all the correspondence in the supplementary bundle. That's not my case. If you recall, my case is that I don't challenge the findings, the primary findings of fact that the first tier tribunal made. The complaint which is made here is the conclusion one draws from that. And the findings that the FTT has made do not support its finding of main object. As I say, ours is a narrow case. It doesn't require me. I'm not challenging what they've said in terms of the findings. I don't need to go through all the correspondence. I entirely accept, for example, as I said in my opening submissions, that the proposal came from a GSA, for example. I don't challenge those findings. What I do challenge is the conclusion that is drawn that there is a main object. There's a main object of avoiding tax in circumstances where all Mr. Gerko and the other members of HFFX have done is being faced with maybe a commercially mad structure where you're taxed on 100% of everything because there's no guarantee you're going to get to your profits at the end of the day, as actually happened with Mr. Badjan, or the structure which was imposed. That's the case in a nutshell. It's a narrow point. Now on condition A, by contrast, I'm told I shouldn't have gone through all the evidence. But in my submission, that was necessary so that the court could understand what were the primary undisputed facts. Mr. Chaco was never saying that none of those facts were true. Those facts were never challenged in cross-examination. Mr. Chaco did cross-examine the witnesses, their qualifications and this and that, mainly going towards the sale of occupational income side. But the basic facts, as I think my learned friend Skeleton acknowledges, were never really in dispute. But what I sought to do is to give the court an idea of the reality of what's occurred, and it was necessary to see that. Now, my learned friend was asked when it came to looking at 774, are A and B exhaustive, essentially? And he said no, because what that's really getting at is it doesn't matter the structure you've got or the way you make your profits. But he can't have it both ways. So either it doesn't matter, in which case he must be accepting the logical conclusion of that. He must be accepting that the FT has made an error of law because it's then focused on things like infrastructure and who's carried out the trades. Obviously that's always going to be the case if you're an employee, as I've said. So he must, on his interpretation of 774, be accepting that distinction, and therefore he must be accepting the FTT has made an error of law, as I say. If he's accepting it doesn't matter the structure you've got, it doesn't matter whether you make your money as an employee, then it must follow from that questions of things like infrastructure, who's actually legally carried out those trades, must be irrelevant. But the FTT essentially placed all of its reasoning really on those facts. In terms of trade and whether HFFX was accepted as trading, the revenue in their statement of case, sadly that's not in the bundle, referred to the HFFX's trade at 4 different points. We can supply a copy of that after the hearing, at paragraphs 14, 15, 25 and 38. The revenues FTT skeleton, which is in the bundle, paragraph 66, again mentions the partner's trade without qualifying it in the way that Mr. Chaco has sought to do before you. That's at supplementary bundle, supplementary bundle 2, tab 21, page 347. And then in the actual transcript itself on this very issue, I would just refer the court to, if we just take up again the supplementary bundle and take up page 240, so So this is day 3, page 125 of the transcript. What he says there is he's making a submission that, essentially what all the HFFX members are doing is essentially like a profession. He's going on about, we compare computer programmers to engineers. This is not 1,000 miles away from what the insurance professions like actuaries do. Well, I would submit it is. Look at huge data sets, but they do it for the next 10 years, and Mr. Gerko does it for the next 10 minutes because of the computing power. And he says, is at least the kind of thing that is done by professionals. And the fact that in this case it was used to buy and sell by the end client would mean that even if that means in this case they were not carrying on a profession, they were carrying on a trade, it's still the kind of activities which are carried out in a profession. So there, especially in light of the pleadings and the fact this point was never taken, that's a fair submission from Mr. Chacko, that it doesn't matter if it's a trade. That's what I understand his submission to be, because one's focusing on what the kind of activity one is engaged in, and it is of a kind carried out in a profession. That's what we understood the revenues case to be in the FTT. And in particular, if you go to the first tier decision, it doesn't really comment on this in any real detail. So if you go to the first tier decision, this is core bundle, bundle 1, tab 16, and go to page 230. There's just a very brief reference at 112 to the trade of the LLP. And then if you recall, you were taken to paragraph 215, this is on page 249, where there's a point being made, well, this is all happening within a trade. Now, it would be odd at this stage if the FTT said, well, I'm not actually satisfied that what HFFX is doing as a whole is a trade, because that would have been the end of the point. So the FTT appears to accept, because it's not in dispute, that HFFX was carrying on a trade, but it's said that doesn't get you home automatically. And that's the point being made at 215. So that's what so insofar as the revenue are now trying to dispute that now, I'd say that's not really open to them. Coming back to the both ways point, in my submission, it must mean that Mr. Chacko must accept that if it doesn't matter the form in which you're doing it, things like who owns the infrastructure or who carries out the trading as a matter of which legal person it is can't matter. That must be an error of law in the FTT decision. But if that's wrong, it also shows the unreality of the revenues approach. As we know, HFFX then transformed into XTX and started trading on its own account. Had GSA as a legacy investor, but it was carrying out trades in its own name at that point. Now, according to the FTT, that makes all the difference in relation to this legislation. You're doing exactly the same job. Maybe you're sitting in a different office, which you've paid for yourself. Maybe you've got your own computer this time, and you're engaging in these trades. But that shows the unreality in my submission of what the FTT's approach was and what ultimately is the revenues approach here, which is if one is going for form over substance, which Mr. Chacko's sort of blowed hot and cold on, then it must make all the difference if one were to apply this legislation to XTX by way of analogy. Even though you're doing exactly the same thing, a radically different outcome applies. In my submission, that obviously not conclusive, but it does show you that something's going wrong, I think, with the application of the statutory section. What one is concerned about is what is in substance going on here. Mr. Chacko then went on to support what the Upper Tribunal said in terms of Brutus and Cousins. I've already addressed that in opening. In my submission, that is an error of law. What you can't do when looking at this legislation in circumstances where the drafter has excluded trade is to say, well, as long as I can get into profession, that doesn't matter, with closing your mind to the fact that what is actually going on is trading activity. So that is just an error of law. And it has never been a dispute that what the FTT did, 209 to 210, in terms of setting out the law, there's never been any dispute that that is a correct approach. We accept that. We obviously rest our case on that. I don't detect the revenue trying to depart from that, but it was at least unclear to me from my learned friend's submissions whether he accepts that that is the correct approach or not. Lastly, in relation to the submissions made in relation to vocation, I'm not going to take you to it now, but if one looks at Graham and Green doesn't actually assist in determining the difference between a trade and a vocation, because unfortunately the judge talks about both. If you read the decision, particularly the highlighted passages, he's talking about trade on the one hand and vocation on the other. They're both obviously organised ways of making money. So that's not going to assist you. But if what the revenue say is true, so vacation ultimately acts as a sort of residual or catch-all category, well, that rather does support the submission which I've made, that one has to reach a conclusion on trade first when one is looking at Section 774, and only to go on to professional vocation if one is satisfied that one doesn't have trading activity in the sense used in Maxi. So that's what I have to say about Condition A. Condition B, Mr. Chaka spent a bit of time going through the facts in the LLP deed. Those are not in dispute. I expressly accepted in my submissions that the cap is a deferral mechanism. The question which we're engaged with here is one of pure law. And the difficulty for Mr. Chaka, as I said, is he has accepted that he is not running a case, that HFFX here is the other person. So you're starting in a situation where the individual appellants are members of this LLP, as is GSAM. And as the FTT said in OD, all of the profits belong to HFFX. As a matter of generality, it is the LLP carrying on the business. And so when one is talking about earning capacity in that context, the only earning capacity of a partner or an LLP member is what is actually allocated to them. Now, I quite accept the point made in relation to 784 that if one were to sell one's partnership share, that is potentially within this legislation. But those are obviously not our facts. And if one starts with that point, that HFFX is the person to whom all the trading profits belongs, and one then allocates that as between the partners, one cannot use this legislation to try and unpick that internal allocation. There was one other point which my learned friend made, which was in relation to 780 sub 1. My respectful submission, that's a bad point. There has been no diminishment of an LLP member's, an individual appellant's LLP member's share here.
So is that 781?
780 sub 1. That provision talks, it's not included in the original 1969 legislation, it comes in later.
Yeah.
And its meaning, I think, is a bit Delphic. If you turn to if you just turn it up, go to page 42 of the authorities manual. It arguably is operative both in relation to 777, but also 778 and 779. It seems to be some sort of catch-all, quite vague supplementary provision. It talks about transactions or arrangements. Well, that is the language used in 777, for example. Then if one looks at 780, if one turns back to 780, it's mainly concerned with property or rights, etc., which is more of the focus for 778, 779. It does, in fairness, if one reads down, I don't think Mr. Chaka took you to this, but if you look at sub 3b, sub 2, it does talk about rights in partnership. That's not relevant here because that's about assigning them. There's been no assignment of partnership rights here. If anything, that's consistent with the fact that the legislation, when it comes to partnerships, is focusing on assignment of rights or transfers of shares in a partnership rather than the individual allocation. So I don't think 780 is really relevant here, unfortunately, for Mr. Chaka. I don't think it really takes the analysis any further forward in relation to Condition B. I've just been reminded about one other point Mr. Chaka said in relation to Condition A. He said it's Condition A for most traders is not really, rather the legislation isn't really going to bite for most traders because they can't forward sell. They can't, for example, create a legal entity, work for it, and then carry on the trade. Well, I simply don't understand that submission. There would have been nothing preventing. Let's take XTX. Let's assume it's just one person doing all of that. Let's say it's Mr. Gerko, who doesn't need any friends. He decides to incorporate himself, takes a notional salary as an employee, and the company carries on doing that business. That clearly is something which one could say is forward selling in the same way that one is forward selling the ongoing profits of a professional vocation. So I simply don't understand that, the point Mr. Chago is making there. The point in relation to trading stock certainly does exist for some trades, but lots of trades don't involve sort of warehouses of stock or warehouses of any other materials, which one then triggers a disposal on when one transfers it into a company. So I don't think you can really limit the legislation to only those kinds of trades, as opposed to the kind of trading activity we're concerned with here. Unless I can be of any further assistance, those are my submissions.
Thank you very much indeed, Mr. Yates, and thank you to everybody, everyone who has spoken, and those who've no doubt done a huge amount of work also in relation to this very interesting set of issues. You'll be relieved to know that we're going to reserve our judgments, and you'll also know how things are dealt with here, but I'll just spell them out once more. The drafts of our judgments will be circulated in the usual way. They will only be circulated to those whose email addresses have already been provided. If you want or need, I should say need, to circulate the drafts to a wider audience, please don't just do so. Please ask for permission and give the further email address, because otherwise there may be some difficulties in that regard, and I wouldn't like you to get into those difficulties. Those drafts are, as you will also know, only for typographical correction and not re-argument. Thank you. You'll also know that we deal with consequential matters in writing. We hope in the first instance that you will be able to agree any consequential order, and if not, please very short written submissions, and we'll decide on those submissions. Thank you very much indeed.